Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about the SEC's proposed rule amendments to modernize and simplify disclosure requirements for public companies, investment companies, and investment advisors. In this LawCast series, I have been going through the rule amendments proposed by the SEC on October 11, 2017, following which I will go through the rule amendments proposed earlier on July 13, 2016, which amendments are slated for action this year. Risk factors, item 503C. A company is required to disclose the most significant factors that make an offering speculative or risky. Although the disclosure is intended to be principles-based, many examples are included in the instructions, and those examples are always included in risk factors that a company proposes. The proposed amendments would move item 503C to Subpart 100 to clarify that risk factors are also required in a Form 10 and Exchange Act periodic reports and not just offering-related disclosures. The proposed rule amendments will also eliminate the risk factor examples from the instructions. Plan of distribution, item 508. Item 508 requires disclosure about the plan of distribution for securities in an offering, including information about underwriters. The term sub-underwriter is referred to in the rule, however, it is not defined. The proposed rules will define a sub-underwriter as a dealer that is participating as an underwriter in an offering by committing to purchase securities from a principal underwriter for the securities, but is not itself in privity of contract with the issuer of those securities. Undertakings, item 512. Item 512 provides undertakings that a company must include in Part 2 of its registration statement, depending on the type of offering. The proposed amendments simplify the undertaking requirements and eliminate provisions that are duplicative because the requirement already exists somewhere else, or that are obsolete due to changes in the law. For example, items 512D, 512E, and 512F are all obsolete and should be eliminated. Item 512C, related to unsold rights offerings that are then offered to the public, can be eliminated as other provisions in the law would require the company to update or complete a brand new registration statement regardless. Exhibits, item 601. The proposed amendments make several changes to the exhibit filing requirements to streamline and reduce the volume of documents, many of which may not be material, which are required to be filed. The proposed amendments also make at least one addition to the exhibit requirement, and in particular, a company must disclose a subsidiary's LEI number if one has been issued. The proposed amendments add exhibits related to item 202 disclosures, registered capital stock, debt securities, warrants, rights, American depository receipts, and other securities to Exchange Act periodic reports on Form 10K and 10Q. Such exhibits are currently only required in registration statements, Form 8K, and Schedule 14A. The proposed amendments also clarify that schedules and exhibits to exhibits need not be filed unless they are, in and of themselves, material to an investment decision. Although historically the SEC did not object to the omission of schedules and exhibits to exhibits with personally identifiable information, the rules generally require the filing of a confidential treatment request for those omissions. The proposed amendments allow a company to omit schedules and exhibits to exhibits as long as a brief description of the omitted document is included. In addition, a copy of the omitted items must be provided if requested by the SEC, though a confidential treatment request could also be made at that time. Likewise, the proposed amendments will allow a company to redact information that is both non-material and competitively harmful if disclosed. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.